25 Soundview Terrace.
Mike Siciliano, Director of Public Works, 12 Pine Street.
Hi, Robert Williams, 20 Lansdowne Drive from Office of Public Counsel.
Dustin McCarthy, Chief Administrative Officer, 569 Orange Street.
Rebecca Bombera, Deputy Chief Administrative Officer, 122 West Park Avenue.
Please proceed.
All right, so I will take you through the proposed process for improvements in non-accepted streets. And then we will have our colleagues dive into a little more detail. So before you, we have a process that we've set forth that would hopefully allow for non-accepted streets to have their day before you of whether or not certain improvements would be managed with city assistance as well. So property owners would bring the concern and identify it. The alders could then hear the concern. Public Works and engineering would then evaluate the street in question, and they would come to a concurrence of whether or not there was an infrastructure update needed. Once that's done, we would go through a formal request process with my office, CAO's office, preparing the official petition to come before the from the alder or property owners for circulation. So either or. Public Works would prepare an estimate of repairs. The estimate would then be prepared for work done in conjunction with the city's annual paving project or as a separate standalone project. The petition would be deemed completed and would be communicated to the Board of Alders for action, and it would be assigned to a hearing through this honorable board. Once that's done, the committee would consider the request, including the items delineated in section D2. So improvements proposed, alternative to improvements, public safety impacts, duration of improvements, value of improvements, and any other relevant items. Committee will then recommend a special assessment to be levied for the improvements as outlined in section D4. So that would include the proportional cost, the specified period of time for repayment, and a reasonable rate of interest for the work that is done. If the request is approved, a favorable action of the board will cause the improvements to be made by DPW, and the final cost of the improvements will be communicated back to the alders. The final cost will be adopted or modified, and the assessment will be recorded on the property record, and the properties impacted will then repay the assessment over time through the standard process of payment back to the city by a homeowner. That is our proposed ordinance. This would apply to in excess of 50 unaccepted streets. When we use the term streets, there are varied levels of what we would deem to be a street, but we would put before this board that there's in excess of 50 that would essentially meet the what's before you tonight.
If I may just add a couple things, there is a fairly bright line that defines what is an accepted street. An unaccepted street, you start to wander into, is this just a glorified shared driveway? It can get kind of murky, and that's why we don't have a better number of, there's exactly, 54 of these, in the city. It gets pretty murky as to what those are considered. So, but we think it's on that order, it's a fairly good estimate of the sort of things that would potentially fall under this ordinance. Most of which seem to have sort of found a way to subsist for quite a long time. We certainly aren't approving things, developments nowadays that go through the City Plan Commission that have these sort of very murky things. Anything that goes through the City Plan Commission, as Alderman Marchand, you know very well, very clearly define what becomes an accepted city street and what stays in perpetuity, the responsibility of the property owner, and also our engineering standards there are things in how it's constructed that make it very clear what's private and what's public. So that's, it's essentially dealing with the decisions that were made, 100 years ago, and things like that now.
I want to also just add that this is, the Board of Alders has the power to order that any unaccepted street be paved or have other improvements like sewer. And so what this does is it attempts to create a process by which anyone that lives around one of these streets can make the request rather than wait for the Board of Alders to just do it for them essentially. So it tries to provide a process that everyone can avail themselves of fairly.
And just for reference, the second sheet that was given to you is the diagram of what is an accepted street. So
I
Mr.
think that's
Zinn,
my cue to talk about that, right? So this, what you see on the second sheet is our standard detail for a typical road cross section. It's published on our website. If any of you have trouble sleeping, we have, I think, 50 standard engineering details or so. One for every suspected unaccepted street. No, I'm kidding. But it's what you see here is a typical cross section. We generally look for about a 50-foot right of way. You have 30 feet of roadway between the curbs, and then there's space for sidewalks on both sides, for grass strips. This is, if you're doing a clean sheet layout of a neighborhood, this is the sort of thing that we would want to see happen, right? And granted, there are accepted streets that are, a little bit off from this. A lot of the unaccepted ones are wildly different from this. And I think that there are some certain functional distinctions about accepted versus unaccepted streets, or some of the alleyways and things you see here, like allowing traffic in two directions on something. They're often dead ends, so things like that. Instead of being 30 feet wide for cars, they're often, on the order of 10, 12, 15 feet wide. There's probably no drainage, there's no curbs, a lot of other sort of physical things that you would expect on a regular city street, that you wouldn't necessarily see in some of these things that are more unaccepted. And I think that's also a distinction to the public, where, if you're, a delivery driver trying to deliver a mattress to a house, you have a fairly good sense that your box truck is going to be able to go down and access, normal accepted public city streets. An alleyway is something that's very, very different. And so there is some, a little bit of flexibility on the exact standards. Like, if it was 28 feet instead of 30, you'll probably find a few of those streets in New Haven. That's the sort of flexibility, not, cutting it more than half. So hopefully that gives you a little sense of kind of some of the concerns that we put into whether to accept the street.
Thank you. So I guess just gonna dive into some questions. I had one, so, at the point, so I guess initially, so the properties that are impacted, and this, are they repaying in the form of a tax? How actually does the property owners or the group of neighbors pay for this? How does that happen?
So the language in the special act says it could be an assessment. So I don't know that it would be structurally the same as a tax, because their taxes can be graduated depending on how much you pay. So I think it's separate. I don't have a further detail beyond that, but it's something that I think could either be defined in this, or figured out. It's
so I'll elaborate on that. I would make the analogy to a tax in the mechanisms by which it's paid. So it can be paid, for those of you who've lived in New Haven a long time, similar to how your WPCA surcharge used to be paid. It's an assessment. It's collected by the city, much like taxes are. It's liened against the property. So if you don't pay, then the city can collect it back at the time of title transfer.
And just a question to myself, let's say, does the majority, so 50% plus one of the residents on that street, must they all be in agreement in order for this work to happen?
That would be before this that would be before the body, the board, to make that determination, depending on what, probably, my guess would be what the work is, what it would entail, and how many people it would affect, right? I think that would be on a case by case by the board.
So opening it up to questions from committee. Alderman Shaw?
Thank you, Madam Chair. I'm just going to follow up on what you just asked, which is when I was reading through the ordinance language, it talked about the majority of the owners. And it just occurs to me that that could be interpreted a variety of ways. If you have 12 properties, for example, you could say 7 of the 12. But what if you have a house with 4 co-owners? Is it majority of the properties? Is it the majority of the owners? Some houses will have one owner, some houses may have multiple owners. So I think when we talk about the majority of the owners, we may need to be a little bit more specific. And I'm just wondering what the intention is for like what constitutes a majority of property owners on a given street or block.
My conception, without having given it that level of thought, was a housing unit counts as one.
Mm-hmm.
And so it would be counted based on property, but certainly that would be something that this committee should think about, play with, alter as it seems appropriate.
I would suggest that the board has already contemplated such distinction in the creation of special services districts, where they that ordinance defines how the majority shall be defined.
And off the top of your head, do you recall what that definition is?
No, not that quickly. I know it exists, I just don't know what it is.
I think that's going to be something we'll need to establish. And did you give any thought to, and I'm not saying you should, but counting differently whether or not a homeowner is a resident of the property or is, lives in Arizona and is charging rent to people who live there?
No.
I don't think so.
Okay. Sometimes we have difficulty establishing exactly who owns a property. If it's owned by an LLC, it could be owned through different corporations and such. Have you given any thought to how we would recommend with that?
Ultimately, jump in, but the responsible party for the property tax would probably be the easiest way to go about that, because ultimately somebody has to be responsible if a lien gets placed on the home for transfer. So I think that would be the cleanest off the top of my head. I don't think we got that far into nuanced situations.
Right. Another one that just comes to mind is like my house is owned by me and my wife, although we have a mortgage with the bank that really owns a portion of that. What if my wife and I disagreed? I guess our votes would cancel each other out, perhaps. And maybe that property would have no vote.
Again, I don't think anybody contemplated the,
Yeah.
These are excellent questions.
It just seems to me that if we're going to establish this through a voting procedure, then we need to be really clear about how we define who the voters would be and how the votes would be counted. So that's one.
Despite, I don't quite remember how, but I think also historic districts, to establish a historic district, there is some vote of the property owners. And so that might be another spot to find some language as to how a property owner gets to vote. And whether you have to, fight it out with your wife in private or public.
It's true. Yeah, we have a sidewalk in front of my house where my wife and I argue sometimes about. So my next question, if I may, Madam Chair,
Absolutely.
is around the cost of the work the city's going to do. Right? I see in your chart here that there's an estimate that comes early in the process so that folks, when they're signing a petition, they have some sense of what that cost would be. Is it the intention of this proposal, of your proposal here, that the full cost of the work being effectuated should be covered by the assessment and that the residents should be 100% responsible for those improvements, or if it would be split between the city and the residents? What's your intention?
So the special act has some language that addresses that. It says that the board can determine a proportional and reasonable amount of the cost of repairs. So it's something that could be considered on a case by case basis for each road, what the board deems is appropriate.
Mhm. The thing that I think is interesting is that if I'm a property owner and I'm casting a vote about whether or not my unaccepted street should be improved, and I get an estimate of how much it's going to cost, part of what I'm going to think about is, well, what is my share of the assessment? How long is it going to be? And how much money is that going to roll up to? But my reading of the ordinance language that you provided makes it seem very possible that this board could decide, the final determination about the assessment and the cost is after they cast their ballots. And perhaps it costs more than anticipated because there's some underlying roadway condition that makes it difficult, or it's uphill and it's hard. I don't know. There's all sorts of things that could affect the cost. So could there be a significant difference between the estimate that is given when I'm signing the petition and when I get the bill, or when the legislation, the order's passed by the board? And how much discretion does the board have in determining what the share is? What if the assumption is, well, it's going to be a 50-50 split? Well, what if we decide it should be 75 them and 25 the city, or vice versa? It seems like the language that I've seen gives us the ability to we could potentially make a different judgment than what the city staff present in the initial estimate of the cost.
I can cover whether estimates can change during the course of construction. The answer is yes. I think we can try to give, estimates that have, sort of boundaries on either side of it and contingencies, and give a sense of what it could be. That being said, you may find something underground. One thing that comes to mind, if there's a sewer that runs under the road, private sewer, the lateral that goes out to the street or goes through someone's backyard, it's supposed to be 5 feet underground and they buried it 6 inches and you suddenly destroyed the whole top of the thing. That's going to be extra expense that you weren't expecting. Or, there's underground rock formations, the ledge and things like that can impede what you're trying to do, depending on, what level of improvement you're doing. So yes, but I think there's, there could be sort of check-ins along the way. And there would be, I think, under this process where, if the board is, for example, if you have a number of people on an alley, let's say there's 8 owners, all 8 of them sign the initial petition. And then, we do our due diligence, Public Works and myself, and, we come up with $1 million to do this. And then they all look at that and say, no, this is crazy. We don't want that. Well, then you can come to the hearing and say, we saw the estimate. We think we do not want to do this. I would, suspect that the board would probably look towards that and say, okay, fine, we're just going to leave it as it is. So I think there are points that you can touch in along that. But it may be, I would caution against sort of having an estimate just at the start. I think you need to kind of have it fairly close in time to when the work is going to happen.
There's also a logic to preparing 2 estimates at the start. The city has significant buying power, especially when it comes to paving. We could quote a standalone job at one price, and then if we quote it in with our large scale project paving, like we're doing right now, that is 50 different street segments, you see a 30 to 40% reduction in that cost. Easily. So that ceiling quote gives you a good sense of comfort, and we can get it at that bulk rate purchase.
Thank you for that. One more question, if I may, Madam Chair, which is in regards to the engineering side of it. I like looking at sheets like this. It's something I get to do every month. But to what engineering standard would an unacceptable street be paved? Is there some view of
So I think
that is?
Yeah, so I think something like this process, we would want to. Paving typically has a 20-year service life, right? So we would want to create improvements where this alley got paved, right? So, I was, let's say there's an alley behind your house that your driveway backs onto. Does it need to be 30 feet wide? No, it can stay the 10 feet wide or 12 feet wide or 15 feet wide that it is now. What we would want to make sure is that we're putting down, the 2-3 inches of asphalt that it needs in order to get a service life of the 20 years, which is what we would expect on a street. At the same time, it's not getting the heavier traffic that we see on the street. A regular street. To give you a sense, a local road has a 4-inch thick asphalt, right? A collector is 9 inches thick of asphalt. So I think you would be pretty close, and we'd look to have a service life for the use of the unaccepted street as it is used today for 20 years would be, my sense. Director Siciliano.
That's pretty accurate, yeah.
Curbing, no curbing?
Again, if it's an unaccepted street, it would stay unaccepted, and therefore, I think that's more driven by the needs of what the unaccepted street is being used for. It'll stay an unaccepted street, so you wouldn't expect sort of the absolute general populace to be going up and down the street. So I think that you have a little more leeway in terms of what the expectation is.
You wouldn't have tree belts in the sidewalks. That's
Correct.
creating.
Yeah, we would not put sidewalks in, for example.
But in terms of the hydrology of the street, the drainage, you'd have to do certain things to make sure it drains well, right?
I think we would. I think we would be a little more lenient on drainage than what you would see on an accepted street, because we would probably try to match the drainage that's there today, unless there were a significant issue identified. Adding a drainage system to a street is a substantial expense. So, if an alleyway is small, it currently drains into the yards and it's fine, and the property owners agree that it's not an issue, then I wouldn't see the need to incur the expense of putting in a full-blown drainage system.
Mm-hmm.
On the other hand, if there's a big, flooding problem and it's hazardous, and that's something that the alley, the people along the alley want to see addressed, that is something that we could give an estimate for, and would be part of all of this.
Just my last follow-up on this is the implications for the city in terms of any liabilities if an improved unaccepted street creates drainage problems that didn't exist before, and people have recourse to like blame the city for damage to their property. And then would this have any implications in terms of plowing the streets and sweep cleaning them, like the city being on the hook for those kinds of things in the future?
Well, I'll address the drainage part, and then as far as being on the hook for services, I'll defer to my knowledge.
So a good percentage of these roads are already getting services and have been for a long time, whether it's refuse and recycling pickup, snow plowing, road repairs. The guys don't drive around with a map showing what is accepted and not accepted. So, in turn, it benefits us in the long run also to, make improvements to these roads. So.
In terms of the drainage, I think we'd be very careful to try to avoid the very situation you talk about, which is create a problem where one non-existent without doing something to address it. If beyond, filling in potholes and things like that, which, really aren't really, hopefully a drainage system, but they can infiltrate some water. So yeah, I think in the case where we're suddenly really changing the hydrology of the unaccepted street in relation to the adjoining properties, we would recommend either curbs or a drainage system to address that.
Thank you, Manager.
Thank you, Alder Marchand. I have Alder Saban on the queue.
Thank you, Madam Chair. I just had a quick question, sort of following up on some of my colleagues' questions about the voting process. And if possible, this was already addressed, but I was wondering, it says owner shall mean any person or entity that owns any portion of an unaccepted street. That's under section 27.154A. And I was wondering, so does that mean that their personal property line goes over the unaccepted street?
In some cases, yes. In some cases, these unaccepted streets are a combination of easements between properties. In other cases, they're part of condo associations that may not seem like normal condos to you. Like the Food Terminal Plaza is a great example of a commercial condo that has an unaccepted street through it, Longini Lane and Painters Lane right there in Food Terminal. And I think Food Terminal Plaza is another street in there. They're all part of that condo association, not accepted city streets. They are not eligible for trash pickup, so not one that we go down or deal with on a frequent basis, but they do meet that definition.
Okay, so I guess I was wondering, in the letter that we received from one of our colleagues about Kenter Place, it describes that some of the people who live on Kenter Place or have access to Kenter or need to use Kenter Place, some of them have addresses that say Kenter Place and others of them don't. But it seems like all of those people use Kenter Place. That's their primary way of driving to their houses. And I just want to make sure that the definition that we have of the people who are able to vote on whether they are going to pay to improve the street are included under the definition that we have. And that it's not defined by whether their address is listed as being on the unaccepted street. That makes sense.
Taking the example of Kenter Place, there are two lines of houses, one on Vista Terrace and the other one on Laurel. I believe the back of all of those properties own half a share of Kenter Place. And so they are actually owners. They're also abutters, you could call them both. So I know the suggestion that Alder Markson had about the definition, and I think it could be an abutter, it could be defined as an owner. Typically it's anyone that is against the property is going to be either, essentially, both. Typically, the way these work is you own to the center line of this common property. It's different in what Ms. Bombero described for condos. So there might have to be a term that captures it. I think a butter might do the trick, owner/abutter or owner of abutting property.
Okay, that's helpful.
Clarify.
Thank you.
It is conceivable that you have a situation where the way or whatever alley it is on one property, like right up to the property line, and then the property across from it has, a driveway that butts right, the edge of the alleyway is right on the property line, right? The alley's on one side, the driveway is on the other. Obviously, both properties are benefiting from this, but it's only on the property of one of them. Now, I don't know if that situation actually exists in New Haven, but that is a spot where having sort of owner and abutter could be useful. It may also, there is a certain amount of discretion in the ordinance already as drafted for the board on various aspects of this. There may be also, and I maybe defer to Rod on this, there may be some discretion for the board to consider who is the beneficiary of this. Having a driveway that ties into this, and this is how you get your car from your property to a public road, is a pretty obvious benefit, right? So that may be a test as well that could be applied by the board and its committee.
And I think that's contemplated in step 2 in formalizing the request through our office doing that due diligence to research the ownership, the history on the unaccepted roadway and the interested parties.
Thank you.
So next I think have it on the queue, Alder for lower and Alder Eva, please.
Thank you, Madam Chair, and I just wanted to jump in really quickly because if we're looking at the special act and just in talking, just in commenting on what my colleague said, it says here that that the persons whose property is in the judgment of said board, especially benefited thereby. So I think that that's the key. And let me just say, can I say it, Madam Chair? What are you gonna say? This would have been better if there was an alder working with you with this. There's just so much to this that we have to do over with the process, especially if you're going to talk about what alders should be doing as far as our process is. You've outlined processes that we wouldn't do. And so it's just my recommendation that the next time you're going to present an ordinance to us that includes the process for alders, we want to have a couple of alders there. I know there was one alder that was working with you, but that alder submitted a whole list of amendments to this. So it's an awful lot to try to swallow and go through. And I'll have more questions after that, I'm sure, but I thought that was important to bring out. With a smile.
So noted.
Thank you.
Thank you, Vice Chair. I have Alder E. Rodriguez on the queue.
Thank you. I would tend to think that every property has an owner. And we have the state ordinances and we have our city ordinances that allow us to converse with neighbors about how to handle matters that could impact both of us financially. For example, if there was a tree in the middle of a fence, I have duplex houses on Truman Street, on Arch Street, on Redfield Street that all have right ways, and I often encounter concerns. And so my question is, if that's those are unacceptable, are you saying that through this revised ordinance that you would give the opportunity to the tenants that are in those duplex homes to address, to share any concern that they may have regarding repairs to the right way that could benefit them versus the alder bringing it to your attention?
We would have to evaluate on a case-by-case basis. If it's just a driveway for a multifamily that there's two tenants and a common owner, I don't know that that would qualify, but we can review on a case-by-case basis as to what definition it meets.
For example, on Arch Street, the duplex homes, there's different owners for each of those duplex homes, and there's often concerns shared as to what to do in reference to repairs to the right way that allows them to go into parking in the back of those duplex homes.
So I think that's more of a shared driveway type of situation. Really not the intent, I think, of anyone, the alders or the city administration to address just a plain shared driveway. Really, this is meant for alleyways that have, 6 to 20, houses on them, for example, multiple houses. I think 3 and under is probably 3, maybe there's a handful of them, but really it's more than 3 or more, I would say is sort of the minimum. And even then, I think we would all want to take a very close look at, whether it's just a shared driveway, as opposed to something that, and I think, again, these are all very hard to kind of write a hard and fast definition because a lot of these things were kind of, wink and nod agreements way back in the day between property owners, or it was, a family where, the daughter was here, the son was here, and parents were here, right? That sort of situation, they all get along, they all figure out when they have to repair their alleyway. I think in these cases now, having the board, to Alder Furlow's point, have that discretion in figuring some of that out, I think it's helpful.
So the unacceptable streets, they don't have a defined owner, whether it's two or three individuals, I mean, or the city itself?
It varies. It could be multiple owners of the property outright. It could be certain owners with a lot of easements to other owners along them. It could be owned by a condominium or a property owner. You have a single owner for like a large complex. It varies from situation to situation. But yes, there is no, usually land has an owner, and so someone owns it. How many other rights are owned as well on that property? How many pieces is it in? All of that can vary pretty widely for these streets.
Thank you, engineer. Thank you, Madam Chair.
Alder Phillips.
Thank you, Madam Chair. Just a question. Has there been any conversation? I'm just wondering how do we get to the place where it's assessed to the taxes? And have we spoke with the assessor? We have the attorney here, but just wondering the legality of that. If I move out of my house, these people are still paying taxes on something that was done previously, outside of the normal structure of our regular mill rate.
Right, so I don't know that it is counted as a tax per se, but it's kind of like a lien that adheres to the property. And so the way I've conceptualized it is if you're selling your property and you still owe, say, $5,000 on this, then either that is attached to the property, and so it has to be dealt with in the transaction. Either pay it off or have the new owner assume whatever obligation that involves.
You see similar instruments, not government issued, but on solar. So solar, when you install in your house, you enter into a similar instrument that's recorded on the land deed, where you enter into a contract that moves with the property, not with the person that entered into that contract. So this would be akin to that.
And it's special assessment districts are an extremely common way to pay for infrastructure in other parts of the country in particular that are seeing development. I mean, New Haven is fully developed, so we're not seeing subdivision after subdivision, but in other parts of the country, these sort of special assessment districts are extremely common, and are the way that, your sewer and your water and all that gets actually constructed. How that legally works as compared to a tax and exactly what it is. I think to most people, it'll look, function fairly similar in the mechanics of how it's paid to a tax, but there's, I'm sure, a lot of legal distinctions.
Have you given any thought to how it will be paid? The time span, how it's broken up?
So again, the alders would consider that when they approve this improvement. I would suggest that it would be probably something that you would do like we pay bonds. So you tie the length of the payment to the length of the use. So a pavement project is a 20-year use. So you can divide those payments over 20 years. Or less if you so chose.
So what would be, I'm just wondering, Attorney, Counselor, what would be the legal ramifications if we gave a certain amount of time for one street and then a different amount of time for another street, and maybe the cost is similar, but because the board said, well, we heard them and they said they don't have a lot of money, so we're going to make that adjustment. Is there any legal ramification upon us if we don't maintain the same standard for every street?
People can always make a claim, so there's probably no way to avoid that. I think that would be treated as maybe an equal protection claim, and where you show that you're being treated differently from others, and it's there's always a risk. I think people have to sustain the burden. I don't know the chances of the success. I think I would encourage there to be probably an attempt to make the payments relatively similar. Whether a claim like that was successful would depend on the facts, essentially, and what's alleged and how many people there were, and any other factors that distinguish the two groups.
Would you recommend something like that be put into the ordinance, some sort of guideline, or, I mean, so, we have to set this up, not just for this street, but we have to set this up for when we're gone and out of here.
Right.
And for those that would follow, so that it makes sense for, how these people set it up for us, or set us up.
It would be prudent to include some language considering all the circumstances or something like that allowed the board the widest amount of discretion.
And I would add to that saying, we pay for our paving through capital bonds or through LoCIP payments. So the instrument, how we pay it might change over time. If you are restrictive in your language and how we pay for it changes, maybe we issue a 5-year bond that year because that's what the advisors tell us to do. And we would want it paid back in a similar time frame.
Are there any water pipes in any of these streets?
Yes, probably.
So if there's any damage and the water company has to go in and dig it up after we paved it.
Water company, I believe, so that's actually a really interesting question because it depends. There's a lot of caveats, right? So the water pipe in question, how many people does it serve? If it only serves one house, then it may be the responsibility of the property owner. If it serves multiple customers, then it would be, I believe, RWA's responsibility. And they would have an easement, and usually that sort of easement would say that they'd have to restore it back to the condition that it's in now. So, for example, if it was a freshly paved, they would have to restore it back to that. I mean, it may be up to the property owners to determine what exactly that means, restoring with RWA, because the city is not a city street. But I think by and large they would patch it as a normal patch that they would do. But yeah, I think there would be, theoretically, if this was set up all correctly, which I'm sure there are places where stuff kind of just goes wherever, but there would be an easement. And I think on a few of these that we've looked at, in passing over my time for one reason or another, there have been, I've seen this one easement for RWA on one of these. So.
They historically do not go curb to curb.
They do not, no.
But even when they mess up our street.
Correct.
And they're told to go curb to curb, it's difficult.
But Mike and I have had a lot of entertaining conversations with RWA.
So I can only imagine a resident trying to get this repaired.
Yeah.
My last concern, a lot of concern, but the last thing that I'll say about this is, I'm just wondering the liability, because I think in a sense, once we pave the street, I think in a sense we are taking responsibility for it. Is that?
Well, so the law, when you consider the city's responsibility with streets that are unaccepted, there can be an implied acceptance. It can be expressed where the city says, yes, we're considering the street, or implied. And implied looks at any improvements to the street, paving, utilities, services like plowing and trash removal. And so any of those things could build a claim that this is a road for which the city is responsible. This would be one act. On the one hand, you have city saying this is an unaccepted street, therefore we'll do this, but we're doing it for you and you're paying for it, which is not the same as an acceptance, saying this is public right of way and we expect that there to be public traffic on this. However, it is something that someone could argue, you're aware of this, you're doing this, you break it, you buy it type of thing, like now you're responsible. I don't think it would be considered, it's not a foregone conclusion that once it's paid through this process that it's an absolute liability like a public road, but certainly it's a step, and it's one thing that you would argue in court. would mean liability for the city.
I do think having the property owners go through this process though, which is a very explicit understanding that this street is different from, say, the street I live on or the street you live on, may help the, showing the record. I mean, anyone can sue anyone at any time for any reason, right? That's what the legal department tells you, right? But I think having a record where the property owners voted, they came to a Board of Alder meeting. The Board of Alders specifically called this out as an unaccepted street. We're doing this. We're, putting an assessment on your property. Makes it look very different from an accepted street in the record and in very official ways, as opposed to if, I'm sure this happened plenty of times a long time ago, but 30 years ago, someone went through and just paved one of these alleys as part of the city's paving program. And, now 30 years later, we want to pave, then that doesn't have the same level of paper trail that, this process very clearly sets up.
Madam Chair, our chief engineer is stating how young he is when he said 30 years is a long time ago. We'll let that pass.
It's a long time for you too.
We've been fixing sidewalks throughout the city. And our ordinance states that sidewalks are the responsibility of the owner. And now we're getting into repairing streets that are unaccepted. And I'm just wondering what that's gonna look like down the road. I'm making a comment because you already answered, but it's.
Well, no. I mean, I think there's a difference because the state imposes liability upon the municipality for sidewalk defects. The municipality can repair it or order that the abutting landowner repair it, but and try and collect money for that. There are other things like the 50/50 program, but essentially the liability is assigned to the city, and it's the city's sort of responsibility to essentially either do the repairs themselves and lien or charge the abutter, or to try to I guess to order that they repair the sidewalk themselves.
I think the key difference is whether it's in an accepted public right of way or not. So I remember a sidewalk, I get involved in a bunch of sidewalk things, as was Mike, where it was the building had like a 15-foot wide sidewalk. 10 of it was in the public right of way, and then 5 of it was on the private, was sort of the sidewalk. It looked like a sidewalk, but it was basically between your building and the property line. It turned out that the trip and fall happened on their side of the right of way line, and that was the happiest day for that attorney. He was done. The city attorney, that case was done for the city. So it's I think a key thing and the key difference is that the state also gives very clearly some liability to the city for defects in the public right of way. And that's why, the sidewalks, even though we pass that liability onto the property owners in ordinance, we also do an ordinance provide for the Board of Alders to allocate money to repair sidewalks. It's not the most straightforward setup under state law. I will admit, it's taken me years to wrap my head around it on sidewalks. It's something I do a lot of thinking about, but it's, I think here, because it's not the public right of way, and it's continually acknowledged throughout this process that we're trying to set up, that it's not the public right of way, I think that's very helpful.
So if someone is injured on one of these private roads after we paved it, then the liability still goes with the property owner.
Yes, that would be our position.
Thank you, Madam Chair. Very interesting. Thank you.
Thanks, Vice Chair. Any other questions from the committee? All right, well, I think seeing none, we'll open it up for comment. Thank you so much for your presentation. Feel free to hang around.
It's always fun to talk about infrastructure.
Good to see you. Chief. Send you there.
Let's see, do you have anyone who's signed up? So on my list, I've, Sal Bercanti. Okay, they left. So then I'll just open it up. Are there any members of the public present wishing to testify in the center? Please come forward. Good evening, right here. If you please state your name and address for the record, you'll have 30 minutes to testify.
I will not say 30.
All right.
My name is David Heilbron. I live at 66 Vista Terrace. I come as, I think noted in Alder Marks' letter, as the kind of coordinator for the residents of the owners and abutters of Kenter Place. I come just to say that we have had a lot of discussion about Kenter Place and about unaccepted streets, and that we have been very lucky to have Alder Marks pushing through this legislation and working on our behalf to rectify a situation for a street that's basically falling apart. About 18 households use on a day-to-day basis for only access to our house via vehicles, or those 4 streets that you mentioned that have actual Kenter Place addresses. And being private property owners with no homeowners association or other mechanisms to help us overcome the hurdle of trying to fix a street on our own, we are looking for something from the city to help us do that process. This ordinance, with its flaws in some ways and with its challenges around language that I think Alder Marks has submitted amendments to help rectify as well too, would be a great step to help us do that. Because in many ways we are kind of out of luck otherwise how to fix our street and how to get our day-to-day access to our street ready to go and safe and usable for our entire community. And not just for us, but for our neighbors. I have many neighbors who walk up and down our street because it's a great place to walk, and cut through in Westville in that area too. So I really appreciate you taking the time to consider this and think how we can make this street and the rest of the unaccepted streets safe and accessible for the entire city. Great.
Thank you. Do you
Thank
have any questions from the community?
I do.
Sure.
Certainly, Vice Chair.
And so for some strange reason, I don't know where this street is.
Sure. You're welcome to come visit anytime.
But I don't know where it is. Where is it?
So I'm relatively new to New Haven, so I don't know every street, but
So I know Westville.
you come down Fountain, past Camacho and all that stuff, you turn left on Vista,
Okay.
and before you go up the hill, you turn right onto the street I always forget, Marblewood, and then you make a sharp left to a street that has drainage at the bottom.
Does it go up the hill?
Yeah.
Is that street?
The one with the big levels that
Okay.
your
Yeah, I know
light
what
will
that
fall
is.
on? Yeah, that one.
And there's no sidewalks there?
No.
Just, okay, I know exactly where that is now.
Yeah.
Thank you.
Sure.
Alderman Shaw.
Thank you for coming and for giving us your testimony. I mean, you heard our discussion here with the city staff. I'm just wondering if you can give us some flavor of the discussion of the residents there, particularly about like the money and, or, you know, I mean, you heard the proposal that you would get an estimate of how much it would cost, and then it might change as we go along, and then it could be, you know, a fairly sizable bill that you guys would be paying back over some number of years. Well, what kind of discussion did you all have about the money part of it?
I'll caution that by saying I can really only speak for myself, and I'm representative of the group a lot by being the last man standing and saying I coordinate a lot of things, but you know, there's a strong feeling, and I share this feeling in many ways, that this, you know, we talked about 30 years ago, this street has been paved by the city, from what we understand, for about 60 years. Multiple pavings done by the city. Because it is a street that is used by the city, and while unaccepted, is very much a street that doesn't have, it's not an alleyway with 1 or 2 homes on it, it's a street with 18 homes on it that, you know, use that street daily for vehicular access, and the only vehicular access to their home. So there's a feeling that, like, why do we have to fight this fight when no one else had to fight this fight before us? Beyond that, though, you know, I think for me, there's an acceptance that I'm never going to be able to pave whatever portion of the street I potentially own myself. And I have strong concerns, as much as I love my neighbors, that I will be able to rally them to put the bill for whatever tens of thousands of dollars it costs to pave a street. We have questions about, you know, understanding an estimate and how you communicate, you know, variance in that estimate. just, back of the envelope math makes it feel like it's fair if you stretch it over the entire life of a 20-year street. Interest that came up today is something that I hadn't heard before, but makes sense, but also would like to learn more and understand what is meant by how much interest you're planning on charging. It feels fair at a certain point to me in my conversations with other folks, but there's still a lot of questions about how long will that be kind of levied or assessed.
Thank you very much. I've been on the street once. I rode my bike up it, and I had to ride my bike back down it because it doesn't go through.
Sure.
It's a dead end.
It's a dead end at the end of the street with, I don't know the proper term, but an easement or right of way down between 42 and 32.
So people who know about can walk through.
Anyone who drives over Terrace sees it come up as well too, but yeah, sure.
Yeah. Okay. So do you and your neighbors put your trash barrels and totes like in this unaccepted street, and does the city go up there and collect your recyclables and your trash off that street?
My wife will be texting. Let me just double check here what's going on here. We do put our trash barrels on there. The city, we've lived there a little over 2 years.
Yeah.
The first day we moved in, the trash barrels are out there, and we've continued to put the trash barrels out there. My understanding is that the city does that.
Yeah.
Because they do it, but I'm not privy to it.
Sure.
Don't fully understand that.
And when there's snow, you've seen the plows come up and plow that street. And
The plowing, I'm never up that early, so it's hard for me to know exactly. Do you need to say that?
Nope.
But snow does get removed. I'm not sure if it's with a full-size truck or by someone does it. I also know that the residents, because we have the kind of strange second easement between 32 and 42, there is an informal collection to help support that as well too, because we use that, and some of that may be used to.
I think I know what you're talking about. 32 and 42. That empties out on Vista Terrace.
Exactly.
Okay. Yeah. So that's how you can make it that you don't have to back out to go back down the hill to get out.
Yeah.
Okay. I didn't realize. Okay. Great. Thank you for that information. Appreciate it. Thank you, Madam Chair.
Thank you so much for your testimony.
Great, thanks.
We'll see none. Thank you so much
Good,
for your
thanks.
testimony for coming this evening. I'm gonna ask if there are any other members of the public present wishing to testify. For a second time, any members of the public present who are wishing to testify? Got their time. Any members of the public present wishing to testify? I think that, Mr. Vice Chair, since there seems to be a lot of things left to determine and figure out, perhaps we should keep this public portion open.
Concurrence.
Excellent.
Sure.
So I think at this time we'll take no action and we'll.
We can go to item 2.
Yeah, so we'll keep the public portion open for this item and we'll move on to number 2 on our agenda for this evening, which is a workshop with our colleagues from Ward 9 and Ward 7. Good evening. If you'd please state your names and addresses for the record, and then please proceed with your presentation.
Of course, Caroline Toby Smith, 45 Nash Street.
Eli Saban, 834 State Street.
Welcome.
Thank you very much. Thank you, Chair Kupo, and honorable members of the Legislation Committee. Tonight, I'm very glad that we're here to present an item on a critical issue in our city, pedestrian and traffic safety. I'm very glad to be presenting it in partnership with Alder Saban and grateful to Majority Leader Furlow for your leadership and guidance in the process. So a little bit of backstory on pedestrian safety zones. Back in 2021, the state of Connecticut, through their Vision Zero legislation, gave cities the ability and the power through their traffic authority to create pedestrian safety zones. Pedestrian safety zones are designated areas within a municipality around schools or community centers or hospitals or beyond, where cities can set speed limits as low as 20 miles per hour and pair the lowering of speed with enhanced safety measures and investments to make streets safer for everyone walking, biking, and rolling.
To add a little more details, so since the state of Connecticut passed this law that was led by one of our state representatives, Roland Lamar, some folks in the community, particularly sparked by Majority Leader Furlow, thought that we should consider changing our city ordinances to make it possible to create these pedestrian safety zones under the new state law. And basically the way it works is the state law says the Board of Alders, or the legislative body of any municipality, can authorize that municipality's traffic authority to create pedestrian safety zones. And when the traffic authority creates a pedestrian safety zone, it needs to be accompanied by an engineering study that considers factors like the amount of pedestrian activity in the area, the type of land use and development, parking, the record of traffic crashes, and those types of factors to determine whether it makes sense to make that area a pedestrian safety zone. And the engineering study is also supposed to include a speed management plan and recommend actions to achieve lower motor vehicle speed, since we all know that just changing the number on the speed limit sign not necessarily going to actually get us lower speeds, and that is of course the goal. And so the goal of the communication in front of the legislation committee today is to create a working group to consider this legislation that was allowed by the state law that passed. Basically, we were hoping to create this working group to figure out the details of the ordinance. I think as we just saw in the lengthy discussion we just had about this about item number 1 on our agenda, it's very important to have lots of different voices at the table, from city departments to members of the board, potentially members of the public, so we can figure out the details of all these complicated. Everything turns out to be more complicated than we think it's going to be at the beginning. So we're hoping that maybe the working group could include representatives from the Board of Alders, from engineering, transportation, traffic and parking, corporate council, the police department, and other pertinent city departments. So that is the proposal. I don't know if Alder Smith has anything else to add, but.
No, that's great. Happy to take any questions.
Thank you for being here. Thank you for bringing this to our attention, and certainly a worthwhile issue to be thinking about. I wonder if there are any questions for the committee to start. Alder Marchand.
Thank you, Madam Chair. Thank you for your presentation. I just want to repeat back to you what I think the gist of this is to make sure that I understand correctly. Essentially, you're proposing the creation of a working group to study the state law, to see what opportunity it creates for the city to amend its ordinance to take advantage of a process that would be different under the ordinance than the way it is now. And so this working group would do a lot of due diligence and homework and come back and report to the board and potentially submit a ordinance amendment. And that's the kind of the potential product of this work group.
That's exactly right, Alder Shaw. So, questions this working group might consider would be, how large is a pedestrian safety zone? It doesn't dictate that. Currently in the state ordinance, it says around a downtown district or around a community center or some sort of, highly pedestrianized area. But this working group might explore how, is that a fourth of an area around a school? Is that the entire city? It would explore that question. It might also explore just various aspects of an implementation plan. What does it mean to have a speed management plan? What is it? What's most important to us in the engineering study? So it would help to bring a group together to think about how do we implement this in a thoughtful and rigorous way in the city.
And it seems to me like the chief benefit of updating your ordinance is that the city could decide to lower the speed limit in certain designated areas without getting approval from the state, which can be difficult to obtain. Is that really the goal here?
That's right.
We still need to notify the state, but we don't have to get approval from the state.
Basically, the Vision Zero legislation created a process for municipalities on their own to lower the speed limits to 20 miles an hour by authorizing the traffic authority to take that action if the engineering study is done and they follow the steps in the state statute. So the idea of the working group is to come up with the ordinance language, hopefully, that would enable the traffic authority to create pedestrian safety zones and set out any other sort of guidelines or procedures that we want to have in place to guide that determination of where a pedestrian safety zone should go.
Well, I guess a question that you might consider is, could the outcome of the legislation give that final say to the Board of Alders rather than the final say to the traffic authority on a particular proposal? Do you happen to know if that's within the scope of what the state is allowing?
It's a really good question. It's something that's come up in conversations preceding this one. I think it would be a question to explore. It's still an open question. It could be both what sort of constitutes as the traffic authority and or do we still want the Board of Alders to play a role in the process in addition to the traffic authority? And so both of those are open questions that the working group would explore, and that's why having Port Council on the working group is really important.
Exactly. I think there are, as Alderman said, a couple of ideas that had been sort of thrown around for the possibility that the Board of Alders could have a role prior to the traffic authority considering the creation of pedestrian safety zones. So maybe if the traffic authority is going to create a pedestrian safety zone, it needs to be considering a proposal that came from the Board of Alders. So it couldn't just come up with the idea by itself. It needs to be either saying yes or no to something that the board proposed. Alternatively, maybe something goes to the traffic authority and then it has to go to the Board of Alders for final approval. Those are just some ideas. And again, as Alder Smith said, the goal of the working group is to figure out, most importantly, what we're allowed to do under state statute, as well as, of course, what the board and the community thinks is best.
Thank you for those answers. Thank you, Madam Chair.
Alder Ian Rodriguez.
My question stems around exactly what do you mean by pedestrian safety zones? And are you focusing primarily in terms of driving? I see here that on page 26 of 26, where you have planning considerations, it says pedestrian safety zones can enhance safety in areas with significant pedestrian activity. This aligns with the city's commission to traffic safety and improved urban mobility. Are you also moving toward safety zones, like, for example, I'll give you an example. We have individuals who congregate in sidewalks and they're doing all sorts of recreation activities. We have concerns about that depending on where this activity is happening. So my question stems on what exactly do you mean by pedestrian safety zones? And are you focusing predominantly on traffic in terms of nearby schools and driving in terms of schools?
It's a great question, Alder Rodriguez. It's specifically focusing on unlocking the city or the traffic authority's ability to lower speed limits for cars in the street. And pairing the lower the speed limit to potentially 20 miles per hour with additional speed management measures. So curb extensions or speed bumps or signage. And in terms of the kind of scope or the area, that's something that the working group would explore. So you named some of them, areas around schools, areas around hospitals, community centers, areas where there's dense pedestrian activity is definitely part of the spirit of the state legislation, and the working group will be able to explore, okay, what is most important to us, what should be the scope in terms of where these pedestrian safety zones can be.
Thank you. Thank you, Madam Chair.
Thank you.
Thank you, Alder. I have Alder Frello, thank you.
Thank you, Madam Chair. I think it's good to just note that this, really what we're talking about is the creation of a working group. And our expectation is that this working group will come back with a very broad and very defined explanation of pedestrian safety zone. They will explore the special act that gives this board of alders the ability to regulate speed. And this is something that I worked on for a long time, so I'm glad they pick up this mantle and move forward with this. But I just want to, Madam Chair, just be direct that we're talking about whether or not there should be working groups. And I think that we should kind of stay in that vein. Thank you, Madam Chair.
Thank you, Pastor. Yeah.
Oh, I'm sorry. Can I take back my thank you?
Absolutely. Yes.
It might be good to hear from Commissioner Marchand, because this went to city plan, and to kind of get some feedback from that conversation. If you remember, I should have whispered it to you before I said it. I'm sorry. I put you on the spot. We hear so many things, but there is a report in here, and just to kind of let the committee know what the feeling was from city plan.
Alder Marchand, can you give some context about the approval and the conversation around this?
Yes, I can. Thank you, Madam Chair. The discussion of it was quite brief. The aldermanic referrals typically come at the end of the City Plan Commission meeting, and those meetings can be very, very late. So oftentimes when we get to the aldermanic referrals, it's 10 o'clock at night. So, but my recollection of the discussion was that my colleagues and I and the commission felt that this is an important issue, that it's worthy of further study by the alders, that this opportunity in the state law ought to be explored. And so that's why the commission gave a favorable recommendation. But the commission didn't opine or give further comment on the details, because those details will come from the working group. Thank you, Madam Chair.
Thank you, Alder. I'll just give it everything.
Thank you. I think this is, the special act to regulate speed is absolutely, and this is the working group, important. I think as you move forward, and plan on getting the working group together, it would be important to hear from other colleagues how it's affecting, all the wards, and how that, working group can help. Bring alders or residents of the community, into that working group, so you can get different views from throughout the city. Because that's important, because we have definitely speeding. Thank you.
Thank you, Alder.
Absolutely. I think we'll be working with our colleagues with the Board of Alders leadership, Julie Frello, who's been leading on this issue, to make sure that we have the best possible representation from all over the city and the right city departments, everybody in the room, to make sure we get the details right and everybody's perspectives are included.
Alder Marchand.
I just have a point of information. I think perhaps our majority leader would be able to answer this. A working group is less a formal creation than a commission or a body, where the ordinance that creates the commission spells out the membership and who appoints them and so on and so forth. The working group tends to be less formal. But my recollection is that our process for forming a working group is that it falls upon the president to decide who would be involved.
Yes.
But typically, she would ask alders to express interest.
Yes.
And so it could be bigger or smaller depending on who's interested in what the president decides to do. Is that correct?
Yes. Yes, sir. I've been talking with the president about this, and so kind of saying, would you consider this? Would you consider that? And so I think we're going to have a really good working group.
Thank you, Madam Chair.
Thank you, Alder. So since there's no voting item in front of us this evening,
I think we can, yes, yes, so I think because we are gonna vote to create the working group to send it to the full board
There we are.
so that, the president will appoint the members, Madam Chair. I mean, I don't, this is a little different.
Yeah.
I would think we would leave it open so that they can come back, but then we would just create another communication, I guess, to bring them back, because it says the creation of a working group.
Okay.
That's my opinion.
Thank you, Vice Chair.
Madam Chair, I'll just note for the record that the agenda indicates that this item would be heard. So it seems appropriate that we ask the public to weigh in on
That's
this
certainly,
before we proceed.
absolutely. Before we open up to the public, are there any other questions from anybody? All right, seeing none, we're gonna open it up to the public. If there's anyone here present wishing to testify on this item. For the second time, if there are any members of the public present wishing to testify on this item. For a third time, any members of the public present wishing to testify on this item. Seeing none, I think a motion is appropriate. Alderman, oh my goodness, Vice Chair Furlong.
Thank you, Madam Chair. I move that we close the public hearing on item number 2.
Second.
And it has been moved in second discussion. Vice Chair Furlong.
I should probably state that the reason why we're closing it on item number 2 is because item number 1 is not ready for prime time yet. And so it might be good to leave the public portion open for that meeting and give one of the makers, I think, of this ordinance the ability to come and share what their amendments are before we consider moving forward. Thank you, Madam Chair.
Thank you, Vice Chair. In that regard, if we, but is that point of information, would we now need to vote on moving the recommendation forward to creating a working group?
Yes, right now we would just need to close the public hearing on item 2 by vote.
Okay,
And then if you will permit, I'll make a motion.
absolutely. All right, so, we have a vote to close the public portion. So all those in favor of closing the public portion, please say aye.
Aye.
Any opposed? Any abstentions? All right, the public portion for item number 2 is closed. Vice Chair Furlong.
Thank you, Madam Chair. I move item 2.
Second.
Item is moved in second discussion. Vice Chair Furlong.
Thank you, Madam Chair. Let's do it. We have trouble through our city. We are trying to create a city that is walkable, that is pedestrian friendly. Our cars are driving way too fast. We need to create better ordinances that have better enforceability. And I'm confident that this working group will explore all those areas and come back to a committee, whether it's this one or to a committee. Well, it will be this one, to a committee with good legislation and an ordinance amendment that will help us continue to do what we do best, and that's keep our residents safe. Or what we're trying to do best, is keep our residents safe. Thank you, Madam Chair.
Thank you, Vice Chair. Alderman Rashad.
Thank you, Madam Chair. I'm also speaking in favor of this motion. I commend my colleagues, the 2 presenters and our majority leader for their work on proposing this. And very much look forward to the end product and the discussion along the way, and encourage colleagues to vote yes on this motion. Thank you, Madam Chair.
Thank you, Alder. Any other discussion? Alder Eva.
Madam Chair, I too stand in support of this moving forward. I believe that the working committee is going to come up with some great measures so that we can keep our children safe, especially around the schools, and our pedestrians and our residents. Thank you, Madam Chair.
Thank you, Alder. Any further discussion? Alder Staven?
Thank you, Madam Chair. I'm also in support, and I just want to again say thank you to our committee vice chair for bringing this issue to our attention. And I look forward to hopefully the working group putting together some legislation that this committee, this body can consider in the future to improve safety on our streets. Thank you.
Thank you. Any further discussion? All right, so let's proceed to a vote. All those in favor, please say aye.
Aye.
Any opposed? Any abstentions? The item passes. Vice Chair Furlow.
Madam Chair, I move that we adjourn.
Second.
Items moved in second. All those in favor of adjourning, please say aye.
Aye.
Any opposed? Any abstentions? We are adjourned.
Okay.
Thank you all.
Easy.
Good meeting.
There's a lot of implications for that.
Yeah.
They have to